Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. You have been summoned here because you have a case on the court's arraignment docket. What the arraignment is, somebody just came in. Just hold on a minute. Yeah. Let him sit on that end back there in the back, so he won't be too close to it. Somebody else just came too? Just sit in the back. Okay, we're back on the record in the arraignment docket, County Court at Law Number 2, which is set for 9 a.m. this morning on today's date of May 18 of 2021. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You've been summoned to appear in court for what is called arraignment. What the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. The case that you have in this court is a misdemeanor case. Criminal cases are divided into two categories. One category is called a felony. The other category is called the misdemeanors. Felony cases are normally referred to as your more serious type offenses. Misdemeanor offenses are normally referred to as petty crimes. However, it does not mean that they are not serious. The difference between the felony case and the misdemeanor case in terms of punishment, with a felony case, you can be sentenced to serve time in the state penitentiary or the state jail. With a misdemeanor case, you cannot be sentenced to serve time in the state jail or the state penitentiary. Your time that you can be sentenced to will be in the county jail. Now, the felony cases are, you usually have your murders. It could be a capital murder or murder, manslaughter type case. aggravated assault, aggravated sexual assault. It could be burglaries of habitations, burglaries of a building. It could be various serious type of drug cases, and a whole host of other felony cases. With your misdemeanor cases, your felony cases, you have different categories. You have a capital murder, which is the highest. You have a first degree felony. You have a second degree felony, third degree felony, and a state jail felony. They have different ranges of punishment. For example, capital murder, if you're convicted of capital murder, it could be life or death. If you're convicted of a first degree felony, range of punishment could be anywhere from 5 to 99 years to life, state penitentiary, and you could be given a fine all the way up to $10,000. If it's a second degree felony, the range of punishment is 2 to 10 years in the penitentiary, a fine that does not exceed $10,000. If it's a third degree felony, range of punishment is anywhere from 2 to 10 years, a fine that does not exceed $10,000. And if it's a state jail felony, the range of punishment is normally 6 months to 2 years in the state penitentiary. And I think the fine is the same, where you could go from $0 to $10,000. All right. Now, with the misdemeanor cases, everyone here who has been called, you have a misdemeanor case in this court. With your misdemeanor cases, is divided into 3 categories. You have the highest one is Class A, second one Class B, and then the lowest one is a Class C. Your Class C misdemeanors are the ones that you normally see in JP court or justice court or municipal court, like traffic tickets, speeding, and just various type of Class C tickets. And the reason why I started there first is because you cannot get jail time. Your punishment cannot be jail time. It's either fine only. So it's a fine only offense. Now, the kind of cases that we handle here are normally Class A and Class B misdemeanors. If it's a Class A misdemeanor, the Class A misdemeanor, which is the highest misdemeanor, the range of punishment is anywhere from 0 days to 1 year, which is 365 days in the county jail. A fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, if we step down to the Class B misdemeanor, the Class B misdemeanor range of punishment is anywhere from 0 days to 180 days, which is 6 months. Or you could be given a fine from $0 to $2,000, or you could be given both such fine and confinement. So now, also with this misdemeanor punishment, or with the punishment, you may qualify for probation. And with probation, you don't necessarily, you go to jail. In probation, you're out on probation serving your punishment. Now, with the probation, there are 2 types of probation. One type is called adjudicated probation. We normally refer to it as regular probation. The other type of probation is called unadjudicated probation, and we usually refer to that as deferred probation. The difference between the 2 is as follows. With the adjudicated probation or the regular probation, it does result in a conviction on your record as soon as you get on probation. However, there is something that is called judicial clemency. Judicial clemency means that the court has the authority to set aside the conviction if the following things happen. First of all, the person has to complete the probation. That's the first thing. The second thing, the time for the probation has to expire. It has to run out. And the third thing is the person has to be successfully discharged or let off of the probation. If those three things happen, then the court, then any complaint, affidavit, or information that has been filed against you can be dismissed. And the court can set aside the conviction, which means that you no longer have a conviction. However, if you get a subsequent or another conviction later on another case, if you get another conviction later on, then the court can resurrect, revive, or, well, the offense that you have judicial clemency on, it could be resurrected, revived, or brought back up, and it can be used against you. If you try to get a license with CPS, they could either deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, when we go to the unadjudicated probation, which is normally referred to as deferred probation, it does not result in a conviction on your record when you get on it. And if you successfully complete the unadjudicated probation, your case can be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. And what a non-disclosure is, it means that we cannot disclose the fact that you were on deferred adjudication to the general public. However, if you violate the terms and conditions of your probation, the state can file the motion to revoke your probation, which means to kick you off of the probation. You can be arrested. You'll be entitled to have a hearing for the court to determine whether or not you violated your probation, your deferred probation. Now, if the court finds that you have violated your probation, then you may get a conviction. If you get a conviction, obviously, your case cannot be dismissed, and you cannot qualify for a non-disclosure. Okay. Now, the forms that you have that have been passed out to you, I will go over the forms with you. Now, as a defendant in a criminal case, you have three options, and that's on the form that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Now, as a defendant, you in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states defendant's choice, marking issues next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed counsel, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, finally, if you want to waive your right to an attorney and to represent yourself, then you will put your initials on the fifth line to the left. Once you have finished placing your initials on one of those 5 lines, then you will sign your name on the line that says defendant, and you will place today's date of May 18 of 2021 on the line that says date. Now, the second page that's on that clipboard is for individuals who want to waive their right to an attorney and to represent themselves. If that's your choice, that you put your initials on the 5th line to the left, then I will go over this form with you. And it reads, waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligent made. Furthermore, I have been advised this 18th day of May of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And you will place your name or your signature on the line that says defendant and today's date, if that's your choice. As a defendant in a criminal case, you also have a right to have a jury trial. And what a jury trial is where Mrs. Lawless is sitting. We call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, and they will decide, after listening to all of the evidence, they will decide whether or not you're guilty or innocent. Now, you also have a right to waive your right to have a trial by jury, in essence, to give up your right to have a trial by jury. And by doing so, then your case would just come before the judge or the court, either by a trial, which we call a bench trial, or through a plea, and the plea could either be an agreed plea bargain or an unagreed plea bargain. You also have a right to have witnesses to come to court. Witnesses, they can testify for you or against you. You can ask them questions, and we call that either direct examination or cross-examination. You also have a right to waive your right to have witnesses to come to court. In essence, to give up your right to have witnesses to come to court. And if that's your choice, then you will not be calling any witnesses to come to court. However, the state will be calling witnesses to come to court to testify. You also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. For example, they have videos, witness statements, etc. You have a right to have access to that discovery. If you have a lawyer, your lawyer will have access to that evidence. Or if you're representing yourself, you will have access to that evidence. All right. You, as a defendant, if you're represented by an attorney, if you're representing yourself, will have an opportunity to talk to the prosecutor. If you're represented by an attorney, your attorney will talk to the prosecutor. If you're representing yourself, you'll have an opportunity to talk to the prosecutor. And the reason why you'll have an opportunity to talk to the prosecutor is to see if y'all can reach an agreement to settle your case. The agreement to settle your case, we call that a plea bargain agreement. If you are able to reach a plea bargain agreement, as the court, the judge does not have to follow that agreement. If the judge does not follow that agreement, you'll have a right to, or you'll be entitled to withdraw, which means to take back your plea of either guilty or no contest. If the judge does follow the agreement, and within 30 days you decide that you would like to appeal your case, and that's you would like to have a higher court to look at your case because you think you've been wrongfully convicted, or the court committed an error by convicting you, then you have to get the court's permission to appeal. If the court gives you permission to appeal, then your case will go up to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. They will decide whether to grant or deny your appeal. If they grant your appeal, then they can either find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, within 30 days of them denying your appeal, you can file a pro se petition for discretionary review, which means that you can appeal it up to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. They are located in Austin, Texas. It is the highest criminal court in the state of Texas. They will review your pro se petition for discretionary review. Pro se means you'll be doing it on your own without the assistance of a lawyer. You'll be pro se, representing yourself. And they could either grant or deny your pro se petition. If they grant your petition, they can find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your petition, then at that point, your conviction will stand. Now, everyone here who is appearing for arraignment, you've already been arrested, you've been to jail, and you bonded out. Every day that you spent in jail can be used as credit towards your sentence. For example, you spent 5 days in jail, the state offering you 5 days in jail, they can give you credit for time served, which means you won't have to serve any more time in jail on this case because you've already served it. Every day that you spent in jail is counted can be counted towards your fine and court costs. For example, every day you're in jail, it's $100 that goes towards your fine and court costs. So if you went to jail on Saturday, got out Sunday, that's 2 days. They're 2 different days. So that's $200. So if you was in jail 5 days, $500, the state is offering you a fine and court costs of $500, then you won't have to pay the fine and court costs because the time you spent in jail has already paid it off. And therefore, the fine and court costs will be taxed and retired. Now, if you have more time, if they offer you 10 days, you got 5, that means you have 5 days to do. So if you got less time than what they offer, but it still can be used toward your fine and court costs as well as your punishment. So for example, they offer you $700 fine and court costs of $700. You spend 5 days in jail, that's $500. You only have to pay $200, not the $700. All right. Now, the other thing is Jefferson County has a program called pretrial diversion for first-time offenders. With that program, they dismiss your case and you can get it expunged from your record. Expunged means erased, deleted, or erased or deleted or wiped off from your record. Now, the way it works, you have to get into the program. You have to get an attorney to assist you to get into the program. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you cannot have a criminal history. Those are the 3 criteria that they use to see if you qualify for pretrial diversion. If you meet that criteria, only thing you have to do is, if you want to try to get into pretrial diversion, just let the court know there's some applications that I think that you can fill out. And the district attorney, well, you would have to get your attorney to submit the letter or the application for you. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has a program that is called Veterans Court. It's for veterans. It's part of the pretrial diversion program. You get into the program, complete the program, case is dismissed, you can get it expunged or wiped off, erased, or deleted from your record, your criminal record. And you just have to be a member of somebody who was a veteran of any one of the branches. That's the criteria. Okay. The other thing is Jefferson County, County Court at Law number 2, the court that you're in, we have a program that is called the Community Safety Initiative. I usually refer to it as the CSI program. With that program, we have partnerships with agencies in the community, such as Spindletop, Golden Triangle Empowerment Center, who has a partnership with CICE. And I'll explain to you the program that we have here in the court. Anyone who have issues with mental health, we have individuals, we have a mental health deputy and a counselor here from Spindletop. They can do private interviews. They can do, Spindletop can do assessments, as well as Spindletop can also do placement, either outpatient or inpatient placement, and provide those services. Also, if anyone has an issue with drugs or alcohol, then OZAR, which is our local drug and alcohol counseling services here, and then Spindletop has a program called ATAR, which is for youth. I think it's 21 years old or younger. With that program, ATAR, as well as the OZAR, that program that they have can be used, anyone who has issues with drugs and alcohol. They can do a private screening. They can do interviews, and they can do outpatient or inpatient treatment. They can set up outpatient and inpatient treatment for you to deal with your mental health, deal with your alcohol or drug issues. Now, with the Golden Triangle Empowerment Center, who they have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program. Individuals who are in the program get trained in the hotel industry, the shipping industry, and the chemical industry, or the chemical industry. Once they are trained in one of those areas, then they will assist individuals with getting jobs in those areas. And I think CICE also has a GED program. So which means that if you do not have your GED, they can assist you with getting your GED, your high school equivalents will assist you in getting into their program as well. Or so now with those programs, is part of our CSI program, the Community Safety Initiative program. The Community Safety Initiative program is also part of our bond conditions, which means that as part of the bond conditions, the court has authority to set conditions that make the community, the individual, as well as the individuals, the victims, that is, safe in the community. And so with the programs, with our community safety initiatives, it's designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our families, go to church. And it's designed to make Jefferson County a safer place. And so one of the reasons that we have that program is to address what is called recidivism. Recidivism means when people are committing crimes over and over. And one of the reasons why people commit crimes over and over is because sometimes it could be drugs, sometimes it could be mental issues. There's a whole host of reasons why, lack of education, etc. But anyway, with that program, Jefferson County Court at Law number 2, I tell people this all the time, we don't have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that come before the court. And then we also trying to make a difference in Jefferson County. And the program is designed with individuals, we do not just arrest the problem, we address the problem. And we believe by addressing the problem, we can produce productive people, and productive people, for the most part, normally do not commit crimes. And so that's part of our pretrial bonding pretrial program that we have, our CSI program. And all of these programs that I just mentioned are free, does not cost individuals anything. Only thing they have to do is have a desire to be part of it. And I said it's a part of our bond conditions. If individuals want to participate, they can, to address some issues that they may have. Now, the other thing is we have individuals here who's from Spindletop. We have Deputy Hinton. He's going to come forward and tell you a little bit about their program. We also have Mrs. Lawless, so she's here. She's one of the counselors. But Deputy Hinton is going to come and tell you more about the program and the services that Spindletop can offer.
Thank you, Your Honor. Good morning.
Good morning.
Like the judge said, my name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. This is my partner here, Ms. Misty. She's a qualified mental health professional with Spindletop. We teamed up together because what we found was people who commonly have legal issues, sometimes there's underlying issues, and those underlying issues are what we want to address today. Sometimes they're mental health, sometimes they're substance use disorders. Either way, our goal and objective is to help you address those issues. You can't hear me?
No, sir.
I'm sorry. I'll speak to you personally afterwards. Thank you for letting me know. So what we do, our goal and objective is to help you if there's underlying issues that is causing some of y'all legal problems. We want to address those because our goal is to get you out of the legal system, get you out of the jails, get you out of the court, and get you into a quality of life that y'all would like to see for yourself. Now, this is a personal issue with y'all. Only y'all can make that decision. What we found, there's 2 obstacles associated with what we do here today. The first one is we don't know if we don't ask. So that's what we're doing here today. We're asking you. And second of all, we don't know if you don't tell us. So we're asking you as well to share any problems that you may be having so that we can help you and walk with you through that, whatever that looks like for y'all. Again, this is gonna be private. We're gonna keep it private. We're gonna protect your privacy, and, but we're gonna be here for you. I just want to thank the judge. He allows us in his courtroom because he cares about people. That's the only reason we're here. So I'd like to thank him for that as well. Now, as the court proceeding goes on, I'll be going out and I'll be speaking to each and every one of you. If you want to speak privately to Ms. Visty, you can do that. So she'll be available to go in the back room and speak with you privately and talk with you about giving you resources, giving you options, and giving you talking about services that may be available that would be beneficial to y'all. Maybe this doesn't apply to y'all. Maybe it applies to your family members. If it does, you're welcome to pick up those resources as well and talk to her, and we can reach out to them and help them as well. It's all about helping people, and that's what we do. Does anybody have any questions? Thank you. Thank you for your time. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, the paperwork that you have filled out on the clipboard, we're gonna have some individuals from the court personnel who is going to come by and pick up the clipboards, and then you're gonna be put in one of the three categories. Either you wanna hire an attorney, wanna see if you qualify for a court-appointed attorney, or whether or not you wanna represent yourself. And so this is gonna take a little time, so just be a little patient with us and help us to get through it. And first of all, before we stop this session, I'd like to thank each and every one of you for the time and attention that you have paid here today. And so just be a little patient with us. We have a little system, and yes, ma'am.
I have a question. I talked to an attorney, and he said that he would be willing to be my court-appointed lawyer if it was okay with you.
A court appointments are based on, appointments are made by the code. We don't you don't come in and say, I want you to appoint me Johnny Cochran. It doesn't work like that.
He told me to mention it.
It doesn't, no, but he gave you wrong information.
Okay.
We go by the code of criminal procedures. We have what is called like a wheel, and whoever name comes up, we go down the list. It's not based on who you want to, or if they want to represent you. It doesn't work like that.
Okay.
Okay, yes.
Yeah, I was arrested twice for the same charge, and each time I've been, I filled out one of these papers.
Oh, so you already have one filled out?
Yes, sir.
Okay, just hold on to that then. We're gonna check if it's in the computer, and so we'll be able to verify that.
Yeah, I filled out two.
Okay. Well, now, okay, let me do this here. We're gonna just be in recess at this time. Sir, won't you come up, and you give them your name, and they'll be able to look that up for you. Won't you come on up and stand in front of the okay, stand over there on the far end on the